The princess is not getting their way. Then today, the judge saying no, it's a no-go. The mayors have been struck off the roll. What do you make of this? What do you make of these? What has happened then, essentially?
I think firstly the judge was correct in terms of the agency. The court will attend any particular matter if it is urgent, and the test in which they would use, they would say, is there a right in which we need to protect? Is there going to be irreparable harm? Are there or no other alternatives that are there? Then the most important question would be, when did you know about this particular issue in which you are approaching the court of?
Yeah.
If you've had ample time to deal with the matters and you've chosen to ignore it, then the court is going to say, no, go and follow the queue. You must give your respondent enough time in order for them to respond at the end of the day, which I think was the case in this case. However, we must remember that the mere striking of the matter off the roll due to lack of agency does not mean that there are no merits in that particular matter.
And that's, actually where I wanted to go. That's actually where I wanted to go, Mpumelelo, because if the judge is saying, yeah, it's not urgent, park it there, it does not necessarily say that you have no case in this particular case. And one wonders if the princesses are so headstrong about this particular situation and feel so strongly about it to the point where they would actually then continue and as you put it, go back to the line and start again. Would they in fact be doing that? And how would that assist them when the coronation is actually continuing despite what they're doing?
At the end of the day, they'll be able to get the matter into court and be able to ventilate whatever missteps that they would have been, or maybe they're alleging that they are. But you must also remember that when it comes to traditional leadership and how a king is selected, that is purely within the realm of your customs and the practices which are performed by the royal family. The Traditional and Khoisan Leadership Act is very clear because it says, I as the president or as the premier, I'm only going to recognize an individual who's been nominated by you as the royal family. As to how as the royal family you go about your business in terms of selecting that particular individual is absolutely up to you. And up until now in South Africa, especially when it comes to the Zulu nation, there's very little that has been written down that you can only be able to go back on, or which is codified law that says this is how you select a king or the next EC. So the only thing that they will need to do at the later stage is then to say, this is the procedure that needed to be followed. These are the shortfalls or the things which were not done at the time. This is what we are complaining about. This is why you are saying that the person who has been selected is not a person who is the legitimate king. And these are the processes in which we recommend must be done in order to rectify that. If you don't do that, then it means that your case is going to fail at the end of the day. But let's also remember that what they came to court about was not about the selection of the next king. They only came there to dispute the content and the manner in which the will was drafted. So when the court looks into this particular application, it's going to only limit itself to the provisions of the Wills Act, for example, because that's the only thing in which it has been asked to come and deal with at the end of the day. So what they would need to do is to go back to the drawing board and say, if we really need to challenge this type of matters, let's think meticulously as to how we are going to do that, but let's be clear and crisp as to what exactly we want, and make sure that we quote the relevant law, follow the correct procedures, and maybe they can be successful in their applications.
I think we're going back to our conversation yesterday where we have an issue of, custom versus what is the Western law essentially now. I mean, it does seem as though the president was, in fact, just acting on that Tradition and Khoisan Leadership Act, but it seems that he's been, thrown into it. His legal representatives being there in court today, and one wonders in what capacity they would then have to argue this particular case about why, for instance, the president did indeed sign a certificate of recognition, because it does seem clear that it was based on this particular act and there was nothing vindictive or, attached to it.
But then they would also have to come back and say, Mr. President, you've recognized someone in which you are disputing. Now, somewhere in the act, there's got to be a portion that would say, if you're disputing the contents of the meeting that has took place within the royal family, these are the procedures in which you must follow. If there's none, then you can always go back to court and say, I want a review of this particular decision which was taken by the royal family. I view them as an entity which at the end of the day, their decisions are going to have an impact not only on them, but on a number of individuals that are there. So I want to make sure that all that they are doing is correct, all that they are doing is just in terms of all the processes that need to be followed. These are the shortfalls that have taken place. I think the most important lesson here is to say, if there's an act that tells us, or a piece of legislation that tells us what to do and how someone is recognized, you have to go back to that legislation and check what were the provisions inserted or drafted to ensure that when there's a dispute, there are ways and means in order to deal with that particular dispute. The president's hands are tied because at the end of the day, he's going to say, I've been given a list or an individual has been nominated. This particular legislation imposes upon me to recognize them. On what basis am I not going to recognize a person in which minutes of the royal family have been given to me? Everything, when I take it to my legal representatives or legal advisors, they say everything is above board, and there are no disputes that are there. The manner and procedure of the dispute is also very important. So if there's no dispute, there's nothing stopping me from signing and recognizing this particular individual as the next ECLO for AmaZulu.
And I want to talk about those particular processes and procedures that the president would have to have gone through before signing the certificate of recognition, those that I would assume are then stipulated in this particular traditional act, which would speak to what has to be fulfilled before that signature is put on the certificate. What processes are we then talking about? I mean, you mentioned the fact that there is this recognition, of course, from the monarchy itself, from the Zulu family, but I suppose there's more that comes to it, that is attached to it. Perhaps if we can get into that.
The legislation is quite clear. It says, royal family, you are going to have to sit down and nominate an individual. So in order to be correct from the side of the president will then say, can I please have the minutes in which you sat down, the list of attendees of the people that attended this particular meeting? Are there real individuals that will verify that they indeed form part of the royal family? If that's the case, what was the nature of the discussion? Who was the person that was nominated? Did they accept the nomination? I want all those in writing. And I would make sure that if I have those particular documents, then the only thing in which is going to stop me if there's non-compliance with legislation. And of course, the Premier of the province will then have to come in and also say, yes, Mr. President, we've looked at all those documents. We are not there to test the accuracy or the veracity of the meeting that has taken place. We are only here to say we have accepted it. It is only those individuals that have an interest in this particular matter that will come and say this meeting didn't take place or this individual is not supposed to be there. However, if you go to court on those allegations, you must then be able to say whoever that alleges must prove who is this individual that was not supposed to be there, what was the impact, was there maybe an illegality when it came to the voting or when it came to the attending of that particular meeting, or was the quorum not enough for the meeting to be complied with? If all of those have been received by the president, from the president's side, it is purely administrative. I have the minutes, I have the resolutions, I have the individuals. The only thing that I do is to sign and recognize, because I'm merely fulfilling the wishes of the royal family as enabled and mandated by the Cohesion and Traditional Leadership Act.
Yeah. Is it safe to say then that, you know, the princesses were in fact acting in bad faith and that they essentially deserve what happened today? Because one would think that they would have known of the processes and procedures that had been taking place, you know, that would have led to President Cyril Ramaphosa signing the certificate. So they would have had this wealth of time to interject and to you know, to object to whatever that they felt had not been done, or the processes or procedures that were not done adequately or correctly. Is it safe to then say that they were actually acting in bad faith? We are bringing it, especially today at this time.
I think it would be safe to say so, because the recognition has happened a long time ago. And the ways and means are stated earlier in terms of the Traditional Leadership Act of disputing whatever that has been there. So there are dispute mechanisms that have been inserted into the Act. If there are none, then you do go back to the court. But the most important thing is, once you have known that there's something wrong that has taken place, that's the opportune time to go back to court. You don't wait up until an event such as this one is going to take place tomorrow and only rush to court within 24 hours and make the particular dispute. But again, coming back to their main application, the only thing in which they confined themselves to in the main application was the issue of the veracity of the will, and when it came to the Queen Mother, her 50% share of the matrimonial property. So if none of those are going to touch on the throne or touch on who becomes the next ISILO. You can't then come to court and say, because I've been given leave to appeal, I want the court all the other things which stem from this particular court case to stop, and up until the particular appeal has been completed. So I do think maybe they may have missed a few steps in terms of the agency, and going back to the drawing board and saying, how do you do this application again? I think it's going to help them.
I mean, you've helped us to establish the fact that, and we have now said that, the princesses may indeed have a leg to stand on, if we put aside the issue of urgency. And should they then continue with the legal process and indeed, something is on their side, what then happens, especially given the fact that we're seeing this pre-coronation ceremony continuing nonetheless, and most likely the coronation itself will take place. I mean, traditionally, everything else is actually just happening. So what then happens in a case where the courts say, in fact, the princesses do have a leg to stand on, should they continue?
But we must also remember that what is important, the court will only give to you what you have asked the court to give you. Yeah. So if you go to court and say, I have a problem with the will, the court is only going to look at the will and say, this is what has taken place. Now, what they seem to have missed is that the will of the late queen may have given a suggestion of a suggestive name. However, it did not say, I'm appointing AmaZulu Misuzulu as the next king. That's the most important one. By saying that, the authority and the discretion of the Zulu royal family was not taken away by the will. The royal family members still had a discretion in terms of saying, we are going to independently think of a person who is going to be the most appropriate in ascending to the throne. So the will had no bearing whatsoever. Even if, hypothetically speaking, the will would have not been read or mentioned the name of AmaZulu Misuzulu, his name would have been nominated. At the end of the day, it had no bearing whatsoever as to whether he was nominated or not. Yeah. So if you are going to have a suggestion that the will is the one that instigated that particular nomination, you are going to have a problem in terms of the merits moving forward. Again, the manner in which the application has been brought to the court is not an entirely correct one, because it does not give, at the end of the day, the reprieve of saying that whoever's been nominated as a SILO, his nomination was wrong, was correct. They only confine themselves to the will, and that is what the court is going to look at. All
right, Mpumelelo, I believe you'll be with us throughout our broadcast, so I'll just say goodbye for now, but certainly we'll catch up with you at a later stage. Mpumelelo Zikalala, thanks very much for that.